Good afternoon, everyone. Just going to find my clicker here. Yeah. Great to see you all and to be here with you all. Thank you so much for having me. I think the last time I was with you all, we were coming out of a fairly difficult period, and I would say that we're still in some transition, but I'm pleased to be sharing some updates with you today that go into our core work, as well as some of the activities related to the transition that we're still experiencing. And I will, of course, touch on things like LSO Connects that I know you love to talk about, and a few other matters of interest today. So let's start with governance. Been a topic of great discussion, I think, for the entire profession and frankly more broadly over the past few months. And I think shouldn't surprise you that the Law Society has been very engaged in governance work following the activities and events of earlier this year related to CEO compensation. And we've struck, as you know, a task force, the Governance Review Task Force. And the work of that task force has been quite intense, and I think we're making some great progress. There were 9 recommendations coming out of the O'Connor report aimed at improving transparency and accountability in governance practices at the Law Society. And quite a bit of that work has involved really consolidating a lot of our existing processes and resources and standardizing these and making sure that they're effective. And of course, we've benefited from expert advice from Dr. Richard LeBlanc, a governance expert who was retained to provide guidance on best practices related to nonprofit governance. So just to give you a brief snapshot of what has come out of that work, we have, formalized the authorities and responsibilities of our key officers and leaders, including the treasurer, the CEO, and the corporate secretary, by way of position descriptions that are now approved by convocation. We have a formal human resources and compensation committee with a detailed mandate and authority, and that's also been approved by convocation, and we also have bylaw amendments to support all of this. This has been a humbling experience, I would say, as someone who's worked at the Law Society for close to 23 years, but also one that I think presents an opportunity for us to ensure that we are doing our work effectively and that we have your trust, because there's nothing more important to us as a self-regulating profession to have that mutual trust. So we are also working on some changes to the Great Library. When I spoke with you in the spring, I reported that we had vacated certain provincially owned space in Osgoode Hall that had historically supported our operations, but actually technically is belongs to the province. So the main thing is that the library remains functional and that we have the main reading room that I think if you've been to the Law Society, and if you haven't, you really should, you know and will recognize with the Corinthian columns and the beautiful ceiling. The main opportunity here is to ensure that we are providing service to all of you. And we are going to do that even with a slightly smaller footprint. And you may not notice the smaller footprint because you probably don't always find yourself in the periodicals room in the basement. But those are the kinds of spaces that are being moved over to the province to support increased access to justice and to support judicial and administrative offices. That transition's taking place over the coming months. So if you do come to the Law Society, and I do encourage you to do that, you may notice books in places that there haven't been books before as we facilitate that move. So in Convocation Hall, in potentially the Barristers' Lounge, the Lower Barristers' Lounge, we will be storing books there while we figure out where we're going to put them. And we do have a lot of space in the Law Society. We're finding space in other corners of the building, including in our basement and other areas. So in 2026, you will notice books. And if you're looking for a space to hold an event, we may have less space to offer you during that time. working very closely with the province to help facilitate this transition in a smooth way. And of course, we'll provide updates as they are needed. I also spoke to you shortly after the March 31st deadline for administrative requirements. You'll recall we had just come out of our first cycle of doing that in the new system. We heard from a lot of you. We talked a little bit about how this was just one part of a broader transformation. Like many organizations, large organizations, modernization is a challenge and has its bumps along the way. And I wanted to once again commend everyone, all licensees and law firms for working with us as we work through the transition. You can't do it alone, and so we know that was a bit of an undertaking on your part. So since that time, we've now, I think, stabilized the system and are continuing to improve it with your feedback. So some of the things we've done recently in response to the feedback we've heard from users is, simple things like reorganizing the tiles on the homepage so that it's a little bit more intuitive and they're alphabetical. We had some licensees participating in monthly payment plans who couldn't easily change their credit card information, and so we've changed that. And, there are other things that are coming soon, and I think as we look to the next round of annual administrative requirements, we all want that to go a little more smoothly this time around, and so things like generating your invoice, I think that was probably like the number one issue we heard, the annual fee invoice, and paying that fee. We're working to consolidate a lot of those steps, streamline the process, including, fingers crossed, a process for law firms to pay on behalf of licensees and a smoother process for that, because I know we had to kind of muddle through that a bit last year. We're going to allow you to print your invoice. We understood that was a problem, not being able to print that. And you'll see multi-factor authentication through text messages, because I know last year it was a pain. You had to do it over email, and that's not exactly how CIBC does it, right? So we're working on it, and we are continuing to work on it. And so on that note, I wanted to say that we've had some focus groups over the past few months with a group of licensees, members of the public, and licensing candidates to get a little bit more into what the challenges are and where the opportunities are. That has been tremendously helpful to us, and we're expecting a final report back on that. We will continue this. If we have to run focus groups every year for a few years till we've got beyond the sort of baseline of the system to make sure it's really evolving in a way that's responsive, we will do that. We need you to be able to use the system effectively in order to do our jobs effectively. So we want you to be able to self-serve as much as possible as well, so you can focus your time on your clients and your legal services. So I just wanted to mention a couple of consultations that are going on, because I think that's it's always our goal when we're doing consultations is to engage all of you, but I also know how busy you are and how you may not be spending a lot of time thinking about what the Law Society is up to. It's important that you are engaged with this work, especially where it's relevant to you and of interest to you. And so there's a few things that we're looking at right now that I want to highlight. The first one is trust account management and enforcement. Sounds exciting. So I know that trust account work and managing trust accounts is a sort of typically, administratively intensive. There's a lot of requirements, and of course we know why that is. It's to work in a way that protects the public. And our experience is the vast majority of licensees, lawyers and paralegals work tirelessly to serve their clients and to provide that high quality service. And we don't have an issue with most. The problem is when you have an issue with a few, and those issues relate to fraud, misappropriation, money laundering, or other forms of trust account mismanagement, we all pay for that, and we all suffer for that. So we have seen an increase in fraud generally since the pandemic. I think that's coming across in a lot of sectors. We heard from Law Pro as well on that. And we see that particularly in the real estate market. And we don't have the perfect regulatory tools to address all of this, because our tools are partially, I mean, some of them are enshrined in the Act, some of them are, some things we can change, but some things we cannot as easily. And when we don't have those tools, that's when we see delays in our investigation process and our enforcement process. That's where we see harm done to members of the public, to clients, and that's when we see the kinds of the articles and the unfortunate activities that we've seen in the last couple of years being reported in the mainstream media. Our entire regulatory model is premised on cooperation, right? Licensees cooperating. We are not the police. We are a self-regulating profession. So with that context in mind, I just wanted to say that the project as a whole is aimed at supporting better regulation in that sphere. What we're seeing is we want to be able to get to the bad actors more quickly and more effectively. And, I might add, we also want to reduce burdens on licensees, as we have the benefit of modern technologies. We have the benefit of digital platforms. So we know that some of our practices and our requirements are outdated. So it's a long-term initiative. It's not all going to change overnight, and it incorporates both operational and policy changes. Just to give you a quick snapshot, and we're not going to spend the next hour talking about Bylaw 9, but as you know, these bylaws are concerned with financial transactions, Bylaw 9 in particular. And we have the Professional Regulation Committee, which is a group of it's a venture committee that reports to Convocation, or makes recommendations to Convocation, is looking at sort of these three areas. Modernization of the bylaw, updating language to clarify requirements, removing outdated provisions, simple things like the definition of a bank, are outdated. Enhancing public protection by narrowing the unnecessary exemptions, but also reducing the burden, making the forms clear. We hear a lot about cash checks. Not all banks are providing them. So, can we use images of checks? So that's the sort of thing that is going to be coming forward in terms of Bylaw 9. And we're aiming to balance our regulatory effectiveness with licensee realities and all in the public interest. We were really fortunate to benefit from the input of the real estate liaison group. I'm not sure if any of those of you in the room sit on that group, but that's a group with some benchers and a number of practitioners. Mark, I saw your hand go up. So that group is incredibly useful to us, has made a number of recommendations on the modernization. They meet regularly to discuss issues of concern, to the real estate bar. And it really is an example of how the Law Society can work effectively and directly with licensees to ensure that our work fits into the realities of legal practice. And it's an opportunity for I think, licensees to understand what we're trying to do and what we're up against at times. Next area of reform or improvement is Bylaw 11. In October, actually, Convocation approved a couple of changes in this area related to the practice review program. So on the one hand, there was a tightening of deadlines with respect to responding to the Law Society. And on the other hand, there's a little more flexibility on the reporting that can come out of that. So we come out to some practices and see really exemplary practitioners doing great things. And there's no need for you to read a 46-page report from us. Perhaps there might be a couple of areas where we would want to direct you to continue to improve or maintain your effectiveness, but we would like to be able to issue those kinds of more focused reports to get to the things that matter. So that's what that's really about. And finally, the authorization and direction piece. So recent committee discussions and consultations with the professions have been focused on a requirement for licensees who hold funds in trust for client to provide what is called an irrevocable authorization and direction to their financial institution. So what is this? This is a tool that would authorize the release of bank records for a trust account to the Law Society. Now, before we panic, I would say that this would only be employed in instances where a licensee refuses to cooperate and there's a concern around financial mismanagement or misappropriation or mishandling. The vast majority of cases, if we have a complaint or we are auditing, we get compliance. The licensee provides the records. The problem is where you don't have that cooperation, you may have someone who is stealing client money, to be honest, and that's the issue. And so you do need sharper tools. So the vast majority of licensees will not even experience this. We will never have to use this, but it would allow us to directly address issues when the Law Society is hampered in protecting the public. I see a question.
There's a microphone at the back, if you don't mind, just so everyone can hear. It's recorded, we can pick it up. Thank you.
Sorry, I was just wondering, I'm Jessica from Sudbury.
Hi, Jessica.
Is this in response to an issue that you're having either with firms or solos, or is it something that the Law Society is kind of undertaking as a new effort to sharpen up its own enforcement? Or is it a problem, I guess, is my question
Yes,
overall.
It is a problem. So, I mean, and
Thank
the
you.
reports, and there's actually some information
Thank
on our
you.
website, thank you, that will discuss what this is. But if you've read, the mainstream news in the last year, you would have read about Cartel and Bowie, which is in the public domain, and a very unfortunate case that we're working through. That's but one example. It's a very severe example, but there's absolutely an issue. We wouldn't be going down this route unless there was. And I think it's a great question. And I guess the issue in large, just in general terms, is that lack of responsiveness can be sort of a sign. It can be a sign, someone could just literally be very busy, but it can be a sign of risk. And where we see risk and we don't take immediate steps, we see a potential for harm to the public.
There's a microphone over on the other side. Thank you.
Hi, my name's Faye Hassan, and I'm from Halton Region.
Hi, Faye.
And this is an important issue for us, and I actually happen to get involved in that Bowie case because I had a client come to me. His first request is, I need a lawyer to sue a lawyer, and of course, I cringed. I didn't want to do that. But then his next comment was, I sold my house and I didn't get my money from the sale. And I practice real estate, and I'm like, oh, that's a no-no. My first instinct was that there's got to be an explanation. Now, this gentleman came to me in January. He had sold his house in October. So a number of months went by, and that just didn't sit well. Fast forward, turns out, yeah, his lawyer ran away with the money. Now, the lawyer gave him the net sale proceeds. What the lawyer didn't do was pay out the bank. So he still had this mortgage that was being, they were asking to pay. And obviously, as lawyers, we understand the whole ramification. But when you have a lay person, he's caught in the middle. He's quite upset. And he asked me, do I keep paying the money? Like, do I keep paying my mortgage? Well, first he said, since I have to pay the mortgage, I guess I still owe the house. I still own the house, so therefore I'm going to go back and move in, or I'm going to sell it again. I'm like, no. There's, bona fide people who actually bought your house. You don't own the house. But I did give him the advice that since you got the net proceeds and to protect your credit rating, you should pay the mortgage, right, until we get this sorted out. And sure enough, title insurance got involved. But they only paid the mortgage that was owing in October when his house sold. They did not give him the money that he had to pay until it was finally resolved in February. And a claim was made to Law Society, and they said no. So, what should we be telling these clients? Should I have told him not to pay?
Well, I'm going to ask the real estate professionals in the room to maybe strike a working group on this. I would say that is, I mean, I don't have an answer to your question right now, but I would say that, we have the tools that we have. We have the compensation fund as a vehicle or an avenue for.
That's what he did. He
Yeah,
made a claim to
yeah,
the compensation fund,
yeah.
but he was denied.
Yeah, so, I mean, unfortunately, what you've just done is helped me make my case for why this is so important. That while it may not be perfect, and but what we can do right now is to put in all the safeguards and tools that we possibly can, so that we could get to those records quickly. We do other things, like we do have interlocutory suspensions and things, and we can advance those things more quickly if we're not chasing someone down for their records, and we can get to them directly. So thanks, Faye, for sharing that, and I'm sorry that you had to be involved, but thank you for being involved, because obviously you helped someone who needed assistance. I realize that I'm at 1:20, and I'm hoping
How about one more question?
Oh, is there another? Oh, one more question. All right, this is the hot button topic. Yes.
So everybody in the room, I suspect, thinks that the direction to the bank you're asking for is overreach. I think everybody would think that. And what you have to do is deal with a few bad actors by your definition. Why isn't there a less intrusive remedy? Why can't you get a court order to produce the records?
Well, actually, we can get court orders in some instances, but it doesn't give us the immediacy that we're after. So, we're.
You can get a court order on an emergency basis. People do it all the time. The Law Society does not need
Yeah, I think
what you're asking for. That's my opinion.
I take your point, and thank you for sharing. There's also evidentiary burdens that are at play in court orders. So do I have 2 more minutes to finish my?
Yeah, I'm not rushing
Yeah.
you. Thank you. I was trying to rescue you.
Oh, that's okay. I think it's important to hear all the views, because this is I'm telling you about consultation. So, I mean, I would encourage you to please engage in the consultation and share all of those views, because we do need this to be an effective regime. Okay. So let's talk about something that's not controversial at all. I don't know if anyone read the Globe and Mail today. We are embarking on a consultation around the licensing process, where our Professional Development and Competence Committee is looking for input on a proposal to, drumroll, replace the current licensing examinations, which, as you may know, depending on when you did your own bar ads, is an independent barrister and solicitor exam. So I did the bar ads. How many people in this room actually did the courses with the substantive exams? Okay. So then how many people did the barrister and solicitor exams? Okay, wow, quite a split. So the current model has been in place for 20 years about, and before that, for many, many years, we had bar ads where we would go and do the courses. The committee is looking at how best to assess candidates for licensure and what are the key risk areas. We heard from LawPro today. The key areas of risk are not knowledge of the law. We know from the Law Society's own regulatory data, the key areas of risk are client service, practice management. Based on these findings and a whole lot of other research that you will see in the report if you would like to take a look at it, the recommendation that's being floated out for your input is a training course. Excuse me. And the training course, would have 3 components: training and instruction to provide candidates with opportunity to develop skills, something that, again, those of us who did bar ads would have experienced. Assessments throughout. I don't know about you, but I had my examination for discovery assessment was scheduled for the day that 9/11 happened, so I didn't get to do my assessment that day. I went home. But, I'll never forget those assessments and the way, we had to prepare for them and show up for them and engage with practical legal skills. And the third component will be a final assessment. So we're talking about a capstone assessment that would evaluate candidates across a number of competencies and skills areas to determine if the candidate has the knowledge and skills required to practice law in Ontario. This is a model that is, that is in place in, I think, 6 jurisdictions now. It's not that the Law Society is saying we would go directly to that model. That's provided by the Center for Legal Education, CPLED, Center for Professional Legal Education. Is that right? Teresa knows. Anyways, it's called PREP. But this whole proposal is about moving to that model. And I know there'll be lots of views on that, and we look forward to hearing from you about it. Finally, I very briefly just wanted to mention a pilot project that we're consulting on. So it's not implemented yet. This is another consultation. We're looking at whether CPD credit could be eligible for, pro bono work could be eligible for CPD credit, and whether that would be an incentivization to support access to justice. This idea has been raised on and off over the years. I'm pleased to see that it's actually being developed and that we can get some input on it. It would offer a practical way for Law Society and licensees to support access to justice while advancing competence. So please send us your comments on that if you can, and the deadline is coming up. Okay, so just, I won't say much more here except to say that we have tons of practice resources. I think our focus, just for your awareness, lately has been cybersecurity, and there are some new checklists there for you online, and I'd encourage you to please look at those. And of course, we have our usual supports that you know about, and I would encourage you to, of course, pursue those as well. Thank you so much, and I appreciate the questions.